I am very pleased to be part of the contingent who's welcoming all the participants of this training program on a matter very significant to and long awaited in the field of legal education. The significance of integrating a clinical legal experience in the requirements of completing a degree in law cannot be overstated enough. Long before these efforts towards institutionalizing clinical legal education in the law schools were undertaken, the advantages as well as the host of the deficiencies of pure substantive focused study that it could address have been a subject of discourse in the legal academic circle. Clinical legal education is relatively well developed in other jurisdictions. The benefits of having a practical component to learning, especially in the professional schools, is universally accepted and practiced. With the advent of legal process outsourcing, transnational legal practice, remote legal counseling, universal social justice advocacies, and other like global collaborations, legal education must conform to the standards fueling our counterparts. We must effectively arm our lawyers with the substantive education and legal skills necessary to compete in the growing global legal market. That is why we are grateful to be at this implementation stage of the development of clinical legal education. The journey was long, with the studies, consultations, dialogues, and learning visits, and there is still a long way to go. And so we engage you, as you are being trained, to be part of this collective that will revolutionize legal education. Law practice is evolving as we speak. As laws continuously develop to adapt to societal changes, processes become more advanced, systems increasingly interlinked, and solutions demanded more complex. The skills required of lawyers likewise change. The future legal practitioners have many diverse and different legal career options, and they require different types of skill sets. In order to address the changing legal market demands, it is imperative that our law schools are equally competent to provide the necessary preparation for law students to face them. With this clinical legal education, the law colleges are reconciling the dichotomy of its role to deliver academic-based discipline classroom instruction and to be a trade school through developing necessary skills by experiential learning. For the faculty and legal practitioner trainers, let me take you back on our first year of law practice. Fresh from law school, we were thrust into the legal world with all these laws and jurisprudence we have studied in the 4 or so years we were in law school in our heads. We felt like we can take on anything. After all, we did pass the bar. But do you remember what we felt when we were handed a case file for the very first time by the partner of the firm, or how lost we felt when we made our first appearance in court? The reality then is that we continued to matriculate way beyond graduating from law school and taking the bar, and we dedicate an additional year or so learning the legal practice and the law out there without the benefit of formal supervision, and consequently, at the expense of clients and their cases from whom and from which we got our experiential legal learning. And so this program is a gift. With the exposure and learning promised by clinical legal education, our upcoming law practitioners will have none of these, or at the very least will only be confronted with substantially diminished like anxieties. Law school education, with its now experiential component, will already serve as an incubation clinic to ensure complete learning of the skills required of lawyers. Gestation of practice-ready lawyers will then start from law school and will not belatedly commence only after the completion of law studies. This modular CLEP training project is intended to help the law schools develop their individual clinical legal education programs and establish their respective law clinics. In undertaking this training, it is important that each participant understand the crucial role that they play in the success of this initiative. Each must understand the goals of the program and must always keep in mind the welfare of their intended beneficiaries. It would be good at this point to speak of the program in this context. What is the mission of our law school? What are the objectives that we want our clinical legal education program to achieve? What are the professional norms that we want our students to focus on? What should we consider as a core basis, our accurate source of determining the direction we want legal education at our respective law schools to take? After we engage in a thorough introspection of our constituent advocacies and responsiveness to the needs of clinic recipients, that is the time we can dive into the design elements, practice setting, risk assessment protocols, client handling matters, as well as other cognitive, developmental, and organizational elements of the program. The training modules will go a long way in guiding law schools in selecting pedagogical choices suitable to the school's CLEP objectives, effecting a strategic implementation that will have minimal impact on curriculum change, and establishing assessment methods that will continuously check viability, relevance, and compliance. The journey will not be without its challenges. Consideration should be given on the continuing alignment of clinical teaching methodologies with the learning goals. This is where the value of the reflection component will play an important role. There will be fiscal and operational issues. Are there enough slots, opportunities available to cater to the CLEP hours required of each student? We should be consistently vigilant that compliance with the program should never compromise the quality of the education and training that the student should have. I envision future expansions toward developing more specific legal skills learning and allow focused skill centers after foundational skill sets learning are fully strengthened. Widening legal exposure to cover still disenfranchised sectors. Earlier, I spoke of clinical legal education being more developed in other jurisdictions. Being relatively young into this as we are, our decided focus on the underserved and social justice markedly sets us apart. The political will to institutionalize clinical legal education program all over the country does not only identify the law schools as key sites for access to justice, but it also ensures that all law students are given equal opportunities for practice-based learning. No law student will be left behind. We are thankful to everybody who took part in this Goliath of a project. The Supreme Court, Associate Justice Alexander Esmundo, the pioneering CLEP team, the Legal Education Board led by Justice Zenaida Lepanyo, the Deans of the Philippine Association of Law Schools, the Asia Foundation, Attorney Carol Mercado, and your team of movers and changers. Module training, mentors, facilitators, institutional partners, all. Legal education and the law profession are grateful to you. Allow me to end with this thought. We speak of the nobility of the law profession, and we exalt practices that sustain that ideology. We should then consider the moral imperative of law schools to regard this lofty goal as its compass and produce ethical and practice-ready lawyers who will make this a continuing reality. Let us go on about our mission to share the beauty and fulfillment brought by the clinical legal education experience.